शुरू कर दें।
Well, gentlemen, we have been discussing the law of evidence for so many days. We went through chapter 3 regarding the relevancy of the facts and studied the other provisions regarding the law of evidence, including the definitions of the words and phrases. Now the question which has been put today is how a document is put forth in evidence. It is very much clear that when there is an oral evidence, then that criterion is only to see whether the man is making the statement according to the relevancy of fact and the fact at issue as prescribed under Article 18. So the Article 18 is the basic article which provides that evidence may be given in any suit or proceedings of the existence of a fact at issue or of a relevant fact. So whenever a fact is to be proved, it is to be proved through evidence of the person who is well aware of the facts, meaning thereby that the evidence must be direct. If it relates to a fact that it can be seen, it should be of the person who saw it. If it relates to a fact which can be heard, it should be of the person who has heard it. And if it relates to a fact which can be perceived, it should be of the person who has perceived it. So the oral evidence must be direct. And so far as the evidence in writing is concerned, the document is to be proved with all its contents. So when we go through the part regarding the evidence, we find that there are two kinds of evidence with relation to the documents. Number one is the primary evidence, and number two is the secondary evidence. Primary evidence relates regarding the document in itself. So the original document is to be put forth before the court for its inspection. And so far as the secondary evidence is concerned, it provides certain grounds when the secondary evidence can be let. In all eventualities, secondary evidence cannot be let. It is always necessary that the document should be proved through primary evidence, meaning thereby the document itself should be produced before the court regarding the contents of the document. So Article 73, I am going to read it. Primary evidence. Primary evidence means the document itself produced for the inspection of the court. If there is an original document available, that document is to be produced before the court for the inspection of the court. So that is a primary evidence as stated in Article 73. We are going to read its explanations. Explanation 1 says, when a document is executed in several parts, each part is primary evidence of the document. There are certain occasions that a document is written in several parts, and there was a custom in the old ages that a document was written jointly and then it was torn, and one portion is given to the one party and the other portion is given to the other parties, meaning thereby that the document is one but has been divided into two for the parties. Whenever the question arises as to whether it is original or not, then both the parts were collected and gathered together to find out that it is the original one. So it means that where a document is executed in several parts, any part is primary evidence. So when all the parts are collected, all parts are primary evidence. So where a document is executed in several parts, such part is primary evidence of the document. where a document is executed in counterpart, each counterpart being executed by one or some of the same, the parties only, each counterpart is primary evidence as against the parties executing it. It is very simple that when there are original and the counterfoil, both are primary evidence. Explanation 2 says wherein a number of documents are all made by one uniform process, as in the case of printing, lithography or photography, each is primary evidence of the contents of the rest. But where there are all copies of a common original, they are not primary evidence of the contents of the original. Meaning thereby that if the original is only one, then all copies are not the primary evidence. The original is only the primary evidence, and the primary evidence means the document itself, which shall be produced for the court for the inspection of the court. So explanation 3 is very simple. A printout or other form of output of an automated information system shall not be denied the status of primary evidence solely for the reason that it was generated, sent, received, or stored in electronic form if the automatic information system was in working order at all material times, and for the purposes thereof, in the absence of evidence to the contrary, it shall be presumed that the automated information system was in working order at all material times. Explanation 4 says, a printout or other form of reproduction of an electronic document other than a document mentioned in explanation 3 above, first generated, sent, received or stored in electronic form, shall be treated as primary evidence where a security procedure was applied thereto at the time it was generated, sent, received or stored. So these are the 4 explanations of the primary evidence. But the main point is that it is always the original which is known as primary evidence. And whenever a document is to be proved, it is to be proved through original document. And primary evidence is put forth before the court for the inspection of the court. Meaning thereby that if the original is not before the court shall not be in a position to inspect it. So for the purpose of inspection by the court, primary evidence is needed. But there are certain circumstances when the primary evidence is not available. Then the secondary evidence, under certain circumstances, shall be allowed. So far as the secondary evidence is concerned, it is under section 70, article 74. What secondary evidence means and includes. Secondary evidence means and includes, meaning thereby that this definition is comprehensive, the definition is exhaustive. All those documents which are included in Article 74 are known as secondary evidence. And any other document which does not fall within the purview of Section 74 shall not be considered as secondary evidence. So I am going through this 74. Secondary evidence means and includes certified copies given under the provision hereinafter contained. Number 2, copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Number 3, copies made from or compared with the original are also secondary evidence. Counterparts of documents as against the parties who did not execute them oral account of the contents of a document given by some person who has himself seen it. So these are the 5 kinds of secondary evidence. So any document which falls within the purview of these 5 categories may be treated as a secondary evidence. Now we got 2 types of evidence. Number 1 is primary evidence. Number 2 is the secondary evidence. Primary evidence is the document itself, the original documents with all its contents and the execution. And number 2 is the secondary evidence. It means and includes only all those 5 categories which have been enumerated in Article 74. So, but these are the kinds which may be known as the evidence of the primary and secondary documents. But the question is whether these are private documents or public documents. So there are 2 kinds of the documents. Number 1 is private and number 2 is the public. So public documents have been enumerated in Article 85. The Article 85 the following documents are public documents. Documents forming the acts or record of the acts. 1 of the sovereign authority, 2 of the official bodies and tribunals, and 3 of public officers, legislative, judicial and executive of any part of Pakistan or of a foreign country. Public record kept in Pakistan of private documents, documents forming part of the record of judicial proceedings, documents required to be maintained by a public servant under any law. And number 5, registered documents, the execution whereof is not disputed. This is very important and we will discuss it in detail. Now what does it mean? The following documents are public documents. Number 5, registered document, the execution whereof is not disputed. Number 6 is the certificate deposited in repository pursuant to the provision of the Electronic Transactions Ordinance. So we see that these are the public documents. All other documents are private documents. So we got primary evidence, secondary evidence, public document and private document. If we have a document in our possession, it shall be either primary or secondary. It shall be either public or private. First of all, we have to see whether it is an original one. Is it a primary evidence? Then we have to see whether it is a public document or a private document. So a document is primary plus public. A primary plus private. A document is secondary plus public. Secondary plus private. So when the document is in your hand, you intend to prove it. You have to see whether it is primary or not. But when you find that it is a primary document, then the second task will be, you will find whether it is a private or public. If you find that it is a private document and it is an original one, meaning thereby it is primary evidence of the private document. Now how to prove it? Primary evidence is to be given, first of all, the document itself for the inspection of the court, and then there is a mode to prove it. First of all, we suppose that a person filed a suit for specific performance of contract on the basis of a contract for sale. He has got an agreement to sell in his possession. So that agreement to sell in its original form is a primary document. And as it does not fall within the purview of Article 85, It is not a public document. It is a private document. Then how to prove it? It is a private document. It is a primary evidence. So the original is to be produced before the court for the inspection of the court. And then the point comes, then the production of the original is not sufficient. You have to prove it. Then we have to see Article 79 to prove it. When a document is required by law to be attested by two witnesses, and the witnesses are available and within the process of the court and are not incapable to give evidence, then these two witnesses should be produced for the proof of the document. So there should be two attesting witnesses alive, available within the process of the court and capable to give evidence. So now the question is, what does it mean when it is required by law to be attested by two witnesses? A document, when required by law to be attested by two witnesses, then the presence of two witnesses is a necessity. Then the evidence of these two witnesses will be necessary, and you will call him, he will produce him, and you will ask him to give the evidence. So attesting witness has been defined in Section 3 of the Transfer of Property Act. It means the person who has seen the executant making his signature or marking his thumb, or in whose presence the executant has accepted the execution of the document is an attesting witness. So the attesting witness has been clearly defined in Section 3 of the TP Act. Now the question is, what are the documents which are required by law to be attested by two witnesses? What are those documents which are required? Article 17 gives the explanation. What are the documents which are required by law to be attested? When there is a financial or future obligation, two witnesses are necessary. Because agreement to sell is an obligation in future to execute a sale deed in favor of a person. So the law says that an agreement to sell requires two attesting witnesses. In order to prove it, you are to produce the two available witnesses as prescribed by Article 79 of the qanun-e-shahadat Order 1984. So the second is that the original is not available. Then we have to see whether we have got its secondary evidence. The secondary evidence as enumerated by me relates to the documents and under Article 74. So under Article 74, if we have a document in our custody which falls within the purview of Article 74, and we have sufficient explanation that the original is not available, the original is lost, original in the custody of other party, and you cannot reach up to the original one, then the circumstances have been given in the law that in those circumstances you can read the secondary evidence. But the secondary evidence does not mean that you will not prove it. It means that it shall be proved as if it is an original one. The secondary evidence will be allowed by the court, and if the court allows you, and the court will allow you on the satisfaction of the court. If the court is satisfied that you are justified in producing the secondary evidence instead of the primary one, then after making an order by the court shall ask you to produce the secondary evidence, and that document shall be proved as if it is an original one. All those requirements which are necessary for the purpose of proving the original one are to be fulfilled while you are proving the secondary evidence of a private document. So the third situation is that the document is primary, but it relates to the public document. Then it shall be proved as a public document is proved. So simple. But when it is, the fourth position is when that this document is a secondary evidence of the public document. When it is a public document and is not the original one but secondary one, then the law requires that the public document, the copy thereof, may be tendered in evidence if it is certified in accordance with law. Meaning thereby that a certified copy of a public document is admissible in evidence, and there is no need to produce the original record as primary evidence. So these are the four categories which we have to meet under the relevant circumstances. Now I come to the point regarding public document, Article 85, Sub-Article 5. A registered document, the execution whereof is not disputed. So there are registered documents available. Now the question will arise whether this registered document is a public document or this registered document is a private document. If this registered document is a public document, then it shall be proved as if it is a public document, and the person having the custody of that document will tender it in evidence. But if it is proved that it is not a public document, when it is proved that it is not a public document, then it shall mean that we are going to prove it as a private document. So this sub-article 5 or article 85 is more important than all other public documents. We are to see registered documents, the execution whereof is not disputed. If there is a registered document, the execution thereof is disputed. Then if there is a dispute regarding the execution of a registered document, it loses the sanctity. It becomes a private document. Suppose a man has a sale deed in his possession. It was properly executed, it was registered, and he is possessing it as his owner, and it depicts that the person who is the custodian of this document is having it as the owner of the property. But the executant comes and disputes it. He states that I did not execute it. It does not bear my thumb impression, it does not bear my signatures, I do not know, I came to know about this document today or a few days ago. Then this document, in spite of the fact that it is a registered document, shall not be a public document. It shall be a private document. So this is the reason why the law says that once a person challenges the validity of a document, even if it is a registered one, the beneficiary is to prove it. The beneficiary is to prove its execution, its attestation by the witnesses as required by the law. Then it shall be proved as a private document. But if the execution is not disputed, then there is no need to prove it as a private document. It shall be treated as a public document. So in the nutshell we can say that if a registered document is disputed one, the execution whereof is disputed, it loses its force as a public document. Generally there happens a mistake that a person says this is a registered one, I am tendering it in evidence. This is not sufficient. The person who is alleging that it was properly executed, that person has to prove the valid execution of this document as a private document, not as a public document. There is a suit for preemption. In that suit, the person who is preempting the property will say that this sale deed was executed by A and I have a superior right. Meaning thereby that in that suit, he is accepting the very execution of this document. And when the defendant comes, he accepts that he purchased the property through this document, and the executant is not in the field, then the certified copy of the sale deed is sufficient to prove its execution. But if this document is challenged by the executant, then I did not enter into any contract, I did not execute it, it does not bear my signature, it does not bear my thumb impression, then the person getting benefit from it, who is deriving benefit, has to prove the valid execution. So this sub-article of Article 85 is very important. Registered documents, if we stop here, it shall mean the following documents are public document, registered document, that is a public document. We can obtain the copy thereof, we can get the certified copy from the relevant record of sub-registrar and can submit it. But if anybody comes and takes shelter on the second part, the document whereof is not disputed, the execution whereof is not disputed, is a public one. But if it is disputed, then it is a private document. So the distinction is to be drawn to determine whether it is a private or a public document. Because the proof of public document is altogether different, and the proof of private document is altogether different. A private document is to be proved by the production of the primary evidence for the inspection of the court, and it is to be proved in accordance with Article 79, if it is applicable, and if it is required by law to be tested by 2 witnesses, then it is to be proved in that way. And whether it requires or not, it will be determined under Article 70. So when a document is disputed one, it should be seen that it is to be proved as a primary evidence in accordance with Article 79, read with Article 17. But if it is a public document, then there is no harm in getting the certified copy thereof and tendering it in evidence. So we find that the document is primary and private. Document is secondary and private. Document is public. Document may be public document, but it may be primary and public, secondary and public. So we are to determine in what category the document falls. We are to see all these things while determining the production of a document. So the main point which are to be seen in it, that how a secondary evidence is to be produced. I have already told you that secondary evidence is to be produced as if it is a primary evidence, if it is allowed by the court. But if it is secondary of the public document, then the tender of the document is sufficient. But the circumstances under which the secondary evidence can be given are to be enumerated by the person who intends to produce the secondary evidence, and the court, after examining it, shall allow him to read the secondary evidence. But so far as the public document is concerned, there is no need to get permission to produce the secondary evidence of the public document, because the certified copy of a public document is per se admissible. So we are to study Article 73, 74, Article 79, Article 17, Article 84 and Article 85 to determine how a document is to be proved.